Meghan Markle is being accused of a secret teenage marriage in Chicago in 1995. The receipt behind that allegation is described first as a paid background search and later as a wedding certificate, even though the material shown does not identify an issuing clerk, a certified copy, a verified groom, a record number, or an official Illinois verification. From that unresolved entry, the story expands into pregnancy, a hidden child, a false age, palace knowledge, and even questions about the validity of Meghan's marriage to Prince Harry. But before one database result can rewrite an entire life, a simpler question has to be answered. Did the record ever identify the correct Rachel Meghan Markle? That question matters because document language creates authority. A background search result sounds provisional. A wedding certificate sounds official, complete, and legally verified. The original video moves between those two descriptions as though they mean the same thing. They do not automatically mean the same thing. Commercial background services can collect addresses, index entries, associated people, court references, and records linked by names or other data. An official marriage certificate is a specific document maintained by a government record keeper. The difference is not technical decoration. It is the difference between a lead that deserves investigation and a legal event that has actually been established. The claim is serious enough to examine carefully. Rachel Meghan Markle is a specific combination of names, and an alleged entry connected to Chicago in 1995 naturally attracts attention. It should not be dismissed merely because the conclusion is uncomfortable or because the source came from a subscriber. A specific name match can justify a proper verification request, but specificity is not authentication. A record becomes Meghan's record only when the identifying fields align. The date of birth, the other party, the event date, the city or county, the record number, and the issuing authority all matter. Without those details, a familiar name is still only the beginning of the investigation. This is where the official record system becomes essential. The Illinois Department of Public Health explains that it can verify the facts of marriages from 1962 onward. Those facts include the parties' names, their dates of birth, the date of the event, and the city or county where it occurred. The department does not issue the certified certificate itself. Certified copies come from the county clerk in the county where the marriage took place. For a marriage said to have happened in Chicago, the Cook County clerk is the official keeper of those records. That creates a direct test, but the video does not present the result of that test. There are therefore 3 document levels being collapsed into one. The first is a commercial database hit, which may be useful as a research lead, but depends heavily on how the vendor gathered and matched information. The second is an official state verification confirming the basic facts of a marriage. The third is a certified county certificate showing the recorded marriage event. The headline presents the claim as though the third level has already been reached. The transcript itself appears to begin at the first. Royal receipts cannot skip the space between them, because that space is where identity mistakes, data errors, incomplete indexing, and mislabeled records can occur. A paid search can feel convincing because money was spent to obtain it. Payment, however, does not convert a private database into an issuing authority. The reliability of a background report depends on the vendor, the source database, the search terms, the date of the search, and the way the result was matched to the subject. Was the search conducted using only a name? Was a date of birth included? Did the vendor identify a marriage license, a certificate, an address association, or a court-related entry? Did the result show both parties? Was the underlying source named? None of those questions is answered clearly in the transcript provided. The identity issue comes before every other allegation. Before asking whether Meghan hid a marriage, the record must show that the bride was Meghan. Before asking whether she married at 14, the record must show the correct date of birth. Before asking whether the royal family knew, the record must exist in an official form that officials could reasonably discover. Before asking whether Harry's marriage could be affected, the first marriage must be authenticated and its later legal status established. The viral narrative begins with the final consequence and works backward. A responsible investigation has to move in the opposite direction. The year 1995 creates the strongest emotional shock. Based on Meghan's publicly reported birth year, that date would place her in her early teens. The phrase teen bride therefore does enormous work before the record has been verified. Yet even the age question requires historical precision. The relevant legal test would be the Illinois marriage law in force at the time, including any age, consent, parental, guardian, or judicial requirements that applied then. Current law cannot simply be copied backward and treated as the historical rule. The proper sequence is first to authenticate the marriage, then identify the parties' ages, and only then examine the statute that governed the alleged event. The video instead uses the shocking age calculation to make the document feel more real. That reverses the burden of proof. A dramatic implication cannot authenticate the source that produced it. The fact that a 1995 marriage would be extraordinary does not make the marriage more likely. It makes the need for precise evidence even greater. The more damaging the allegation, the more important it becomes to show the original record rather than asking viewers to complete the missing fields through suspicion. The word sealed is used in a similar way. The video says the alleged record was sealed in December 2018, shortly after the royal wedding year, and the timing is allowed to suggest institutional intervention. But sealed has legal meaning only when it can be connected to an authority. Which court issued the order? What record was sealed? What was the case number? Who requested the sealing? What legal basis was used? Did a clerk confirm that the record was restricted? Or did a commercial database simply display a status label? Without those details, the word creates mystery without establishing a legal event. A database field can be misread. A record may be unavailable, suppressed from a vendor's display, incomplete, removed, restricted, or simply no longer returned by the search system. None of those possibilities is automatically a judicial sealing order. The timing may justify a question, but it cannot prove palace involvement. The claim that a record was sealed after Meghan joined the royal family requires more than a date appearing on a screenshot. It requires an official source chain showing who acted, what was restricted, and under what authority. The palace question therefore comes too early. The original video asks whether royal officials vetted Meghan and whether they knew about the alleged marriage. Those are powerful questions because audiences assume that a royal marriage must involve extensive checks. But the formal instrument of consent confirms only that Queen Elizabeth gave her constitutional consent to the marriage of Prince Harry and Rachel Meghan Markle in March 2018. It does not disclose what private checks were performed, which agencies were involved, or what records were reviewed. The official wedding in May confirms the marriage took place. It does not answer an unverified allegation from a commercial search. There is also a second legal test that the viral claim almost completely skips. Even if the 1995 entry were eventually authenticated as Meghan's lawful marriage, that fact alone would not establish that her marriage to Harry was invalid. Investigators would then need to determine whether the earlier marriage ended through divorce, annulment, death, or another legally recognized process before May 2018. A prior marriage and a subsisting prior marriage are not the same proposition. The first concerns whether a marriage began. The second concerns whether it was still legally in force. This is the two-record test. First, prove the marriage that allegedly began in 1995, then search for the record showing whether and when it ended. Illinois provides processes for verifying marriage facts, and dissolution records would require their own examination. English law can treat a later marriage as void where a party was still lawfully married, but that legal consequence cannot authenticate the factual premise. A legal rule tells us what would matter if the facts were proved. It does not prove those facts for us. The viral story jumps across both stages. It moves from an unresolved name hit to a teenage wedding, then directly to questions about annulment of the royal marriage. That progression sounds decisive because each step raises the stakes. Legally, however, the chain remains incomplete. No authenticated first marriage is shown. No groom is securely identified. No dissolution search is presented. No evidence establishes that any earlier union, even if real, remained in force in 2018. The headline reaches the legal consequence before the first factual foundation has been laid. The photograph introduced in the video creates a different kind of evidence problem. A picture of a young Meghan in white clothing beside a man is treated as possible proof of a wedding. Another interpretation of her appearance is then used to suggest pregnancy. Yet photograph authentication answers a narrow question: whether an image has been digitally altered or fabricated. It does not authenticate the caption, the occasion, the date, the relationship between the people pictured, or a medical conclusion about someone's body. Even if the photograph were completely authentic, it would prove only that the photographed moment occurred. White clothing does not establish a wedding. Two photographs with different men do not prove that one must be a prom and the other a marriage. A body shape does not establish pregnancy. The identity of a man in an old image cannot be settled through resemblance alone. The proper evidence would include the original source, the date, the event, the photographer, other images from the same occasion, contemporary captions, and named witnesses who can explain the context. The 94% true phrase used around the image also needs to be placed in its proper category. Image tools may estimate whether a file appears manipulated, but a confidence score about digital alteration is not a confidence score about the story attached to the photograph. A real image can carry a false caption. An unedited photograph can still be dated incorrectly, taken out of context, or interpreted through assumptions about clothing and appearance. Pixel integrity is not narrative integrity. This distinction is especially important for female viewers because the claim does not remain limited to a possible document. Meghan's teenage body becomes part of the evidence file. Her clothing is treated as a wedding record. Her shape is treated as a pregnancy record. An alleged database entry becomes a motherhood claim. The men in the pictures remain largely unidentified background figures, while the woman is required to explain every dress, every date, every relationship, and every change in appearance across decades. That is not an argument that Meghan must be believed about every issue. It is an argument about evidential fairness. Before any woman is asked to disprove a hidden pregnancy or a hidden child, the person making the allegation should produce an authenticated record capable of supporting it. Pregnancy cannot be established by body shape. Parenthood cannot be established through a name appearing in an unexplained database result. Privacy is not a birth certificate, and the absence of a public explanation is not a medical record. The original video moves from the photograph to an alleged birth-related record in 1996, but no certified copy issuing authority, child's identity, parental fields, or verified relationship to Meghan is presented in the transcript. A name can appear in a birth index for many reasons, depending on how a database organizes parents, children, witnesses, households, or associated records. Without the full document and identity fields, the result cannot support a hidden child conclusion. Because the claim concerns a potentially private individual and reproductive history, the standard should be exceptionally high. The same caution applies to speculation about Meghan's age. The video uses employment memories, an advertisement timeline, and statements about a frozen yogurt job to suggest she may be 6 or 7 years older than publicly reported. Those details may create inconsistencies worth checking, but they do not outweigh established public chronology without an official record. Memories about teenage work can be approximate. Businesses may not retain complete records from decades earlier. Advertisements may be dated incorrectly in online discussion. None of that proves a different birth year. More importantly, the age claim is used to make the marriage claim flexible. If Meghan was born in the publicly reported year, the alleged bride would have been extremely young. If that seems legally difficult, the story proposes that she must be older. In other words, one unsupported allegation is used to rescue another. That is not corroboration. Evidence should narrow possibilities. Here, the theory expands whenever a contradiction appears. That is one reason the original video feels persuasive to viewers who already distrust her. It gathers many unrelated suspicions and places them beside the alleged certificate. Once an old photograph looks unusual, a pregnancy claim feels more plausible. Once the palace is imagined as powerful enough to investigate anything, a sealed record feels more plausible. But plausibility created through accumulated dislike is not the same as independent proof. Royal receipts has to separate the main receipt from the character narrative built around it. The question is not whether Meghan has ever given inconsistent accounts, managed her image carefully, or made choices that critics dislike. The question is whether a specific legal marriage occurred in Chicago in 1995. That claim must stand or fall on the record itself. Character impressions cannot fill missing certificate fields. The strongest argument supporting further investigation should still be acknowledged. The exact name combination is unusual enough to deserve an official check. The alleged location and year are specific. If the full background report includes a matching date of birth, a named groom, a county, an event date, and an official record reference, the claim would become materially stronger. If an Illinois verification or certified Cook County certificate then confirmed those details, the public timeline would require serious reconsideration. That possibility is why simply calling the entire story impossible would be premature. The evidence shown is inadequate, but inadequate evidence is not the same as proof that no related record can exist anywhere. A fair investigation leaves room for new documentation. It identifies exactly what could change the verdict. Here, the decisive materials would be the full commercial report, its underlying data source, an official state verification, a certified county certificate, and any dissolution or annulment record. The strongest counter case is that the commercial result may concern another person, may combine data incorrectly, may refer to a license that never became a recorded marriage, or may have been mislabeled by either the vendor or the commentator. Similar names, old addresses, household associations, and imperfect public databases can create false matches. That is why Illinois asks for more than a name when verifying marriage facts. Dates of birth, the date of the event, and the place of the event are designed to distinguish one record from another. The transcript does not give the audience enough information to decide between those possibilities. The groom remains unidentified or speculative. The exact record type is unclear. The issuing authority is absent. The alleged sealing is unsupported by an order. The photograph lacks verified context. The birth claim lacks a certified record. The dissolution question is not answered. Yet the reputation verdict is delivered as though all of those steps have already been completed. The claim inflation is one of the most important receipts in the story. The evidence remains one unresolved data entry and an old photograph, while the accusation expands into a secret marriage, pregnancy, motherhood, false age, palace deception, and an invalid royal wedding. Each new conclusion depends on the previous conclusion being true, but the conclusions are not independently documented. The story grows. The receipt does not. For women watching, There is a familiar imbalance in that progression. The woman's private history becomes a public test she can never fully satisfy. If she does not answer, silence is treated as confirmation. If she denies the claim, the denial may be described as damage control. If no public record is found, the record is said to be sealed. If her age makes the alleged marriage unlikely, her age is declared false. Every missing piece is converted into another reason to suspect her. That is why the evidence standard matters beyond Meghan. A woman should not have to publish her complete reproductive and marital history simply because an online database returned a result. Public figures can be investigated and powerful claims can be tested, but the investigation must remain tied to documents that genuinely support the accusation. Otherwise, curiosity becomes an impossible burden. Prove that every unverified story about your body, childbearing, and relationships never happened. The royal family should not be used as a substitute for missing evidence either. The argument that palace officials must have known assumes the marriage was real, discoverable, correctly indexed, and still legally relevant. It also assumes a particular vetting system without an official description of its scope. The formal royal consent confirms that the institution approved Harry's marriage to Rachel Meghan Markle. It does not disclose the confidential process behind that approval. Silence cannot tell us what was searched or found. The legal hypothetical can still be explained honestly. If an authenticated prior marriage existed and had never been legally dissolved, that could raise a serious question under the law governing the later marriage. But the word if is doing essential work. The possibility of a legal consequence does not strengthen the weak evidence for the earlier event. It simply explains why accurate verification would matter. A responsible final verdict must therefore separate 5 categories. What is proven? A video presents an alleged commercial background search result connected to a 1995 marriage claim and uses an old photograph as supporting suspicion. Official records confirm that Queen Elizabeth formally consented to the marriage of Prince Harry and Rachel Meghan Markle in March 2018, and that the wedding took place in May. What is credibly established about record procedure? Illinois can verify marriage facts using names, dates of birth, the event date, and the city or county. Certified marriage records for Chicago are maintained by the Cook County Clerk. Those official routes provide a way to test the claim, but no completed verification or certified certificate is presented in the material reviewed. What is disputed? Whether the commercial result represents a marriage, whether the person in it is Meghan, whether the photograph shows a wedding, and whether any earlier union existed. What remains unknown? The vendor's full data, the alleged groom, the record number, the issuing authority, the meaning of the sealed label, and whether any dissolution or annulment record exists. What has the public headline exaggerated? It has converted an unresolved database, hit into a confirmed teenage wedding, then used that unverified wedding to construct claims about pregnancy, a hidden child, a false age, palace complicity, and the validity of a royal marriage. The headline promises a certificate. The evidence presented does not yet establish one. The final receipt is the gap between the document that was described and the document that was actually shown. A background report can be a lead. It is not automatically a marriage certificate. A matching name can justify verification. It does not complete identity resolution. An authentic photograph can establish that an image is real. It cannot prove a wedding or pregnancy. A prior marriage could matter legally. It cannot threaten a later marriage until both the first marriage and its continuing legal existence are proved. Meghan Markle's public life has produced enough disputes that an invented certainty is unnecessary. The 1995 claim can be investigated without deciding in advance that she lied or that every unusual detail proves a hidden family. The evidence should be allowed to lead the conclusion. At present, The material does not establish that Meghan legally married in Chicago as a teenager. It establishes that a commercial search result was interpreted that way. So the real mystery is not whether a shocking headline can be built around the name Rachel Meghan Markle. It clearly can. The real mystery is whether the person behind the headline was ever matched to an official marriage record. Until the document type, the identity fields, the groom, the issuing authority, and the dissolution history are verified, the alleged certificate remains a claim about Meghan's past, not a proven part of it.